Hi everyone, before we start, I just wanted to say a big thanks for all the support as we're currently 9/10 of the way towards achieving target 1, which was to achieve 300 Instagram followers, where being a massive fan of professional wrestling, I'd hit you with my Hulk Hogan impression as the pretend Dunk Dogan and hopefully have Dunkamania running wild at some point over the summer. There's a shirt company on Amazon that's making a killing off of me. I have no idea what they think with all the orders I've put through, and I should probably rein it in. But as long as you're willing to follow me, I'm willing to come up with more crazy ideas and put that on a shirt. Anyway, now, welcome from Law with Dunk, the Law Guy, and today is day 44 of the Case Today series journey, covering cases across criminal law, tort law, contract law, and the English legal system. If you ever have a case you want me to cover, feel free to pop it in the comments section and I'll get round to it if I can. Today, I'd like to continue with the doctrine of transferred malice and explore how it can be seen in the case of R.V. Latimer, 1886. You'll remember from yesterday's Day 43 recording that transferred malice refers to a principle in criminal law that relates to mens rea, that provides that the defendant will still be held to be guilty of a criminal offence where their malice or mens rea is towards an intended victim or primary victim, but the actus reus is performed upon someone else, i.e. the actual victim or secondary victim. To find the defendant guilty of having both the actus reus and mens rea at the same time upon the actual victim, all the courts do is simply transfer the mens rea over from the intended victim to the actual victim. Thus, the criminal liability equation is intact and the defendant can be found guilty. For more details on this, please go back to the Day 43 recording. Now, for R.V. Latimer, 1886. In this case, after engaging in an argument and fight with another person in a pub, the defendant, Latimer, took his belt off and swung it at the person he was arguing with, i.e. the intended victim. The belt actually hit a bystander and caused injury. It was a lady who got hit in the face. The bystander here would be the actual victim for the purposes of transferred malice. To be clear though, the belt ricocheted off the first victim, the man to whom Latimer was arguing with, and the belt buckle ended up hitting the bystander, causing a wound. Latimer was found guilty of unlawful wounding under Section 20 of the Offences Against the Person Act 1861, despite not intending to hit or harm the bystander, as the court merely transferred, presumably the defendant's direct intent to cause some harm to the intended victim, i.e. the man Latimer was arguing with, to the actual victim, i.e. the bystander. This ensured that there was both the actus reus and mens rea present for a Section 20 offence. And that's it for today. Thank you from Law with Dunk, the Law Guy, and I'll see you Thursday.